Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Danish Hakim bin ANUAR. My matrix number is 1232233. The citation for this case is Mariam and Muhammad Arif 1971 1 MLJ 265. The case happened at 26 January 1971 at Selangor. The case was heard before the Judge Abdul Hamid H at the High Court of Kuala Lumpur. The first party, which is Mariam, is the applicant, a mother of two children who has been divorced by the respondent, the father of the children. The other party is Muhammad Arif, which is the respondent, a father to both children and a husband to Mariam. This case is about an application for the custody of two children. Next, the first issue is whether an application can be made to the High Court even if the consent order by the Qadi regarding divorce has obtained approval from the both sides. The second issue is whether the Guardianship of Infants Act 1961 is applicable or not. The case starts with the applications for the custody of two children who are still minors, a girl named Nur Izan, 8 years old, and a boy named Muhammad Faisal, 3 years old. On September 1963, both husband and wife went to the Qadi Court in Petaling Jaya to obtain a divorce. After that, the court granted a conditional divorce, which is talak ta'liq, on the condition that the respondent will have the custody of the both children, but the applicant had the right to visit them. After that, both husband and wife remarried again with the other person. In the High Court of Kuala Lumpur, the applicant stated that since the divorce, the children have been kept away from her, and she strongly suspects that they are not being well cared for by the respondents. Moreover, there were 5 circumstances where she attempts to visit the children, but there were no relatives available to inform her about their whereabouts. Then that, the applicant stated that the boy and the girl were found in various inappropriate situations. For example, the boy was found with a broken bottle in a cradle, dirty and with a smell of pee. And for the girl, she was found with lice on her head, was locked in a house with a respondent's little brother who are mentally ill, and mentally abused by the respondents when he said that he don't want to take care of her and her little brother. Moreover, the respondent claimed that the custody consent order for the children has been granted to her by the Qadi's order with a voluntary and unconditional agreement of the applicant. The respondents quote Section 46(1)(b) of the Selangor Administration of Muslim Law Enactment 1952 stated that even though the applicant can appeal, the applicant is late because 1 year has passed since the order was made. The enactment stated that the appeal must be made within 14 days after the consent order was granted. Therefore, the respondent stated that the applicant has no right to appeal. And the respondent also argued that according to Islamic law, on behalf of Mazhab Shafi'i, a mother who has remarried with the other man has no right for the custody of the children. Section 45, Subsection 6 of the Selangor Administration of Muslim Law Enactment 1952 stipulated that if there is any difference or dispute between the decision of Grand Qadi or Qadi and the decision of the civil court, then the decision of the civil court shall prevail. Section 5 of the Guardianship of Infants Act 1961 stipulated that the mother shall have the equality of power in applying to the court in respect of matters regarding the infants. Section 11 of the Guardianship of Infants Act 1961 stipulated that the judge shall prioritize the infant's welfare in any cases. Court's decision, the applicant is entitled to file the application even if the consent order was made by the Qadi, and the court, in this case, the High Court of Kuala Lumpur, has the jurisdiction to hear this application. After that, Section 5 and 11 of the Guardianship of Infants Act 1961 are applicable. as there is no evidence to suggest that these provisions are in conflict or contrary to Islamic law or Malay customs. In doing so, the judge Abdul Hamid said that it is not my intention to disregard religion, but that doesn't necessarily mean that the court must adhere strictly to the rules laid down by the Muslim religion. Number three, if there is conflict in civil law regarding custom and religion of the parties for someone under the age of 18 who follows Islam, then the decision need to be made in accordance with religious and customary practice, and vice versa. Number four, the custody of the female child is granted to the respondent and the custody of the male child is granted to the appellant until he reach the age of 7 or 8 for the purpose of their welfare as stated under both English and Islamic law. The primary considerations is the child's welfare. From my point of view, I see that there is a conflict of jurisdiction between civil law and Sharia law occurred in this case. Therefore, I would recommend that we can establish a clear legal framework that delineates the jurisdictional boundaries between Islamic law and civil law. For example, the amendment of Article 1211A of the Federal Constitution that set the boundaries and framework between Islamic law and civil law. Number two, I can see room of improvement for our court system. Maybe in the future we can explore the possibility of a unified court system that can handle both civil and Sharia matters and help reducing conflicts arising from separate jurisdictions. To conclude, this case sets a good example for the conflict of jurisdiction happened in Malaysia before 1988, and Article 1211A was a smart move by the Parliament to make for the betterment of the Sharia court's position and status in the future.